Welcome back to the deep dive. Our mission here is, well, pretty sharp and simple. We take these dense stacks of legal and professional source material, really complex stuff, and we pull out the critical insights.
Absolute need-to-know parts.
Exactly. And deliver them straight to you so you can get, instantly and thoroughly well informed, especially on these high-stakes topics.
Absolutely.
Today, we're doing a deep dive into something foundational, the legal and ethical scaffolding. The framework that really supports every single action healthcare professionals take in imaging science.
That's right. And look, this isn't just some theoretical ethics chat.
No.
Our sources lay out a very structured, very legal roadmap. It's all about professional accountability.
Right.
The focus today is on the real legal risks, the liabilities, patient rights, and some key terms you absolutely have to grasp. Torts, negligence, consent, these govern your daily practice.
So we're distilling the knowledge you need to understand what accountability really means. In legal terms.
In the highest terms, yeah. It's serious business.
And the gravity here, it really can't be overstated, can it?
Not at all.
I mean, the initial takeaway from all our research is crystal clear. If you're a radiologic or imaging science professional, you are, without question, legally liable for your actions, both in the diagnostic room and during patient management. So accountability isn't just, about doing a good job. It's about meeting legally established standards.
Legally defined standards of care.
We really have to know where those legal landmines are buried. Okay, so let's unpack the first big category of legal actions that can pop up in a clinical setting. Torts.
Right.
When the law talks about a tort, what does that mean exactly?
Well, simply put, it's a private or civil wrong or an injury. It's something separate from, say, breaking a contract.
Okay.
And it usually leads to a court remedy, most often financial compensation damages, they call it.
Got it. And crucially, we're starting with intentional torts here, meaning the act itself was, well, deliberate.
Exactly. When we talk about an intentional tort, we're looking at situations where the professional consciously did something that violated the patient's rights.
Like their personal space, their autonomy, their dignity.
Precisely. And the key thing isn't always that the professional wanted to cause harm.
Right.
It's that they intended the action that then resulted in that harmful outcome, often breaching established rights. The intent relates to the act, not necessarily the consequence.
Okay, that makes sense. Let's start with a pair that often gets confused in everyday talk, but legally they're distinct. Assault versus battery.
Ah, yes, the classic duo.
Let's define assault first. Based on our sources, it's any willful attempt or threat to inflict injury, combined with the sort of apparent present ability to actually do it, and an intentional show of force that makes the victim reasonably fear or expect immediate bodily harm.
Notice the key elements there. It's the threat and the fear that results from it.
So it's all about the victim's state of mind.
Entirely. It's the apprehension of contact. So imagine a technologist gets frustrated, maybe threatens to strap down a non-compliant patient tighter than needed.
Okay.
If that threat causes the patient genuine fear of immediate unjustified physical harm, well, that's assault, even if the technologist never actually touches them.
Wow. So no physical contact needed for assault.
Correct. It's the credible threat creating fear.
That distinction is so important because battery then is the next step. The physical part.
Exactly. Battery is the physical follow-through, the realization of that violation. The definition is any unlawful touching of another person.
Unlawful touching.
Without justification or privilege or excuse. And critically, the intent to actually harm the person is irrelevant for battery.
So even if you didn't mean to hurt them.
If the touching itself was unauthorized or unwanted, legally, it's battery.
And how does this play out in the clinic? Where's the immediate risk?
The most common path, honestly. Forcing a procedure without getting or confirming valid consent.
Consent again.
Always. A patient might seem cooperative, letting you do the prep work. But if they clearly say, stop, I don't want this injection, and the technologist goes ahead anyway, that unauthorized touch is battery.
Even if the injection was medically the right thing to do.
Doesn't matter. The touching was unlawful because consent was withdrawn or never properly given for that specific act.
Okay, but let me push back a bit here. What about emergencies?
Good question.
Say a patient is really confused, maybe trauma, medication, and the procedure, maybe a critical CT scan, is needed right now to save their life. Are we acting under some kind of emergency privilege then? Does that necessity wipe out a battery claim?
That's a really crucial point. And yes, it brings in the concepts of justification or privilege.
Okay.
In a true emergency where the patient can't consent, they're incapacitated, and there's an immediate threat to their life or limb, well, the law generally allows action under implied emergency consent.
So there's a legal defense?
Yes, it provides a defense against battery, but the absolute key is documentation.
Always documentation.
Always. You have to show the procedure was genuinely, immediately necessary, and getting actual consent was impossible. Outside that very specific emergency exception, though, any touching beyond what's consented to is unlawful. Full stop.
Understood. Okay, let's shift slightly. What about violations of freedom and reputation? Starting with false imprisonment. How does that even happen in a clinic?
False imprisonment is defined as the conscious restraint of someone's freedom without proper authorization, privilege, or consent.
Conscious restraint.
And in radiologic science, this is incredibly relevant when we talk about managing patients, especially with physical restraints or maybe patients who are sedated.
Right. So if a patient is awake, lucid, and says, I've had enough, I want to leave now. But the technologist says, nope, you have to stay until the paperwork's done. Or maybe they use immobilization straps just for convenience, not because it's strictly medically needed and documented. Is that where the line gets crossed?
That's exactly it. If you apply a restraint, it must be medically indicated. It needs a proper physician's order, and the patient needs continuous monitoring.
Okay.
Without that proper authorization and procedure, restraining someone is an illegal deprivation of their freedom. We often see this challenged when patients are confused or agitated. The legal test is, was their freedom consciously restricted without adequate justification or privilege?
Makes sense. Now, moving to reputation, we have defamation.
Right.
Defined as holding someone up to ridicule, scorn, or contempt within their community. And it relies on spreading false information that harms them. We usually think of this with public figures, maybe celebrities or politicians.
Yeah.
How does it apply in healthcare?
Well, in healthcare, defamation often gets tangled up with privacy violations, IPA violations, things like that.
How so?
Let's say a professional carelessly shares false information about a patient, maybe wrongly claiming they have a certain disease they don't actually have, or maybe making up details about their personal life. And this false information gets shared with other staff, or even worse, somehow gets out publicly. If it harms the patient's reputation, their standing, maybe even their access to care, that's defamation.
So professionals need to be incredibly careful about what they say, even just casually to colleagues.
Absolutely. Spreading unverified or negative comments about patients, even among peers, is risky. If it's false and causes damage, it's a potential lawsuit. Protecting patient reputation is part of the job.
Got it. Okay, one more in this intentional category. Fraud. The deliberate violation of trust.
Yes, fraud. Defined as the intentional perversion of truth.
Intentional perversion.
For the specific purpose of inducing someone, the patient, an insurer, whoever, to rely on that false information to their detriment.
To their harm.
So this would be systemic, like billing fraud. Or can it be individual actions, too?
Both. It can absolutely be individual. For example, intentionally lying about your qualifications as a technologist.
Oh. Or lying about whether the equipment was properly calibrated, maybe just to speed things up. Or, and this is a big one, deliberately falsifying records, changing procedural documentation, or even results to cover up an earlier mistake.
And with everything being digital now, electronic health records, that must add new ways to commit fraud.
It absolutely has. We're not just talking about scribbling something out on a paper chart anymore.
Right.
Fraudulent documentation now could mean digitally backdating entries in the EHR, manipulating digital images beyond standard, accepted processing, of course, or falsely certifying that required safety checks were done when they weren't.
That's serious.
It is. Our sources really emphasize the moment you intentionally deceive a patient or their insurance company or their employer, either for some gain or to avoid getting caught for something, that's fraud. And it carries huge legal consequences, often criminal charges on top of the civil tort lawsuit.
What strikes me about all these intentional torts, assault, battery, false imprisonment, defamation, fraud, is that they all really highlight the fundamental respect that's legally owed to the patient.
That's a great way to put it.
Their person, their autonomy, their information. These are all about deliberate breaches of trust or boundaries.
Precisely. They represent crossing lines that the law strictly protects.
Okay, so we've laid out the serious consequences if you intentionally cross those lines. But now we need to pivot. We need to talk about the legal challenge that honestly comes up far more often in everyday healthcare.
Yes, the big one. Negligence.
Right. And this deals less with malice or bad intentions.
Much less. It's more about carelessness, maybe inattention, and oversight. Fundamentally, it's about failing to meet the professional standards required to keep patients safe.
Okay, so how does the law define negligence?
The core definition is the failure to do something that a reasonable and prudent person, guided by ordinary considerations, would do. Or, the flip side, doing something that such a person would not do.
So it's measured against this theoretical reasonable person.
Exactly. It's an evaluation of your conduct against an objective standard. Not what you thought was reasonable, but what the community expects.
That concept of the reasonable and prudent person is always interesting in law. It's objective, like you said, not subjective.
Correct.
So it doesn't really matter if the technologist was having a bad day or felt rushed or was dealing with difficult equipment.
Well, the law asks, what would an ordinarily competent professional in those exact same circumstances have done? That's the benchmark.
And that objective benchmark leads us directly to the most critical concept in negligence cases, right? The standard of care.
Absolutely. That's the yardstick against which negligence is always measured, the standard of care.
And how do we define that?
It's defined as the degree of skill proficiency, really knowledge and care that's ordinarily possessed and used by members in good standing within that specific profession.
Members in good standing. So your peers, basically.
Your competent peers, yes. So let's say a patient gets hurt because maybe the professional miscalculated a radiation dose for a child, or maybe they failed to notice a critical change in the patient's vital signs during a long MRI scan. That failure, that omission, is judged against what other competent radiologic technologists, the members in good standing, would typically have done in that situation.
And how does this actually get established in court if there's a lawsuit?
Great question. It primarily relies on expert testimony.
So other professionals from the same field come in.
Exactly. Peers from the same discipline testify about what the accepted norms of practice actually are, what's expected.
Who else?
It also relies heavily on things like the hospital's own protocols and policy manuals.
Ah, the internal rules.
Yes. And published professional guidelines, from organizations like the ASRT or ACR, and even peer-reviewed scientific literature about best practices. So if the hospital's policy clearly states you must perform a specific safety check before giving contrast, and the technologist skips that check, maybe because they're busy, they have legally fallen below the standard of care defined by their own institution.
And this standard, it's not static, is it? Right. Especially in imaging science, things change so fast.
Absolutely not static. It's dynamic. It evolves rapidly with technology, new research, new safety findings.
Which leads to a really critical point for anyone listening.
Yes. A key takeaway from our sources is this. Practitioners who don't stay current in their field.
Keep up with CE credits, read journals.
Right. Or those who fail to follow currently accepted procedures and standards. They may well be held liable if a patient gets injured as a result.
So if there's a newer, safer way to do something, maybe a protocol for reducing radiation dose, and an injury happens because someone used an older, higher dose technique,
that could be deemed negligent, because the ordinarily competent member in good standing would likely have known about and implemented that updated, safer standard. Staying current isn't just good practice, it's a legal safeguard.
Okay, now, sometimes a bad outcome happens, and it really seems like it must have been due to some professional oversight. But maybe it's hard to pinpoint the exact single careless act that caused it. This brings us to a very specific legal theory, right? Res ipsa loquitur.
Ah, yes. Res ipsa loquitur. Latin phrase. Means the thing speaks for itself.
The thing speaks for itself. Catchy?
It is. And it's a legal doctrine used in negligence cases when the circumstances surrounding the injury strongly suggest that negligence must have happened, even if there's no direct proof of exactly what the careless action was.
So it's like the outcome is so obviously wrong that carelessness is presumed.
In a way, yes. It's a mechanism that allows the patient, the plaintiff, to bring a case even without being able to point to the specific negligent act. This is often crucial if the patient was unconscious or sedated during the procedure.
So it kind of flips the usual burden of proof.
It can, effectively. The court might infer negligence based purely on the event itself, and then the defendant, the professional, or the hospital has the tough job of proving they were not negligent. It's a powerful tool for patients harmed in situations where they couldn't possibly know what went wrong.
But the courts don't just apply this lightly, right? There are strict conditions.
Extremely strict. For a court to even consider applying res ipsa loquitur, 3 specific elements must all be met. This is vital for listeners to understand.
Okay, element number 1.
First, the type of injury must be one that ordinarily wouldn't occur unless someone was negligent.
Okay, like what? Give me an example.
Classic examples often cited in law textbooks are things like surgical instruments being left inside a patient after an operation.
Right. That shouldn't happen without carelessness.
Or maybe a patient getting a severe burn from imaging equipment that was completely under the professional's control during the procedure. These aren't things that just happen spontaneously.
That makes sense. If a patient goes in for a routine, non-invasive scan and comes out with, I don't know, a huge cut, it's hard to imagine how that happens without negligence somewhere.
Exactly. So that's the first hurdle. The nature of the injury itself points towards negligence.
What's the second element?
The second element is often where the legal battles happen, especially in a complex place like a hospital. The activity or instrumentality causing the injury must have been under the complete control of the defendant.
Complete control.
Yes. This is frequently contested. If, say, the radiographer was the only person operating the machine, the only one administering the contrast, the only one positioning the patient, then establishing their complete control is usually straightforward.
But what if it's more complicated, like, say, a patient falls off the imaging table?
Right.
The table itself might be maintained by the hospital's engineering department.
Mm-hmm.
Maybe a nurse helped apply the immobilization straps, and the technologist was the one who actually moved the table. Control seems shared there.
Precisely. And if control is shared, or maybe the injury resulted from an equipment malfunction that was the responsibility of a third-party vendor, or the hospital's maintenance schedule was inadequate.
Then what?
Then the individual technologist can argue that the second element, complete control, isn't met for them. And therefore, res ipsa loquitur shouldn't apply to them directly. It might apply to the hospital under corporate liability, but not the individual tech.
Okay. So documentation about who did what, equipment checks, following policy, it all becomes critical again.
Crucial for potentially defending against this specific doctrine.
Okay. And the third element for res ipsa.
The third element relates to the patient's own actions. It requires that the plaintiff, the patient, must not have contributed to their own injury in any significant way. Meaning, if the patient, for instance, got clear instructions, don't move during this part, or tell us immediately if you feel dizzy.
Okay.
And they consciously ignored those instructions, moved suddenly, and that caused them to fall or get injured, then the theory probably fails. They contributed to the harm.
But what if they couldn't contribute? Like if they were unconscious, heavily sedated, or maybe immobilized and developed a pressure sore?
Then the third element is clearly met. They were incapable of contributing to the injury. And that strengthens the argument that negligence should be inferred under res ipsa loquitur.
So analyzing those three things, the type of injury, who had complete control, and whether the patient played a role, really shows how deep the law gets into the nitty-gritty of how procedures are actually performed.
Absolutely. It scrutinizes the entire operational sequence when things go wrong.
Okay, let's shift our focus now. We've talked a lot about the actions, intentional or negligent, that can lead to legal trouble for the practitioner. Now let's look at the flip side. The fundamental rights of the patient that the practitioner absolutely must protect. We're moving into the core of patient autonomy here, specifically confidentiality and informed decision-making.
Yes, and these concepts are really the foundation, the bedrock of the entire parent-provider relationship.
How so?
Well, at its core, the patient has a basic, fundamental right to determine the course of their own diagnosis and treatment. It's their body, their health.
Self-determination?
Exactly, and exercising that right absolutely requires two things. First, complete control over their personal health information. And second, the absolute freedom to accept or reject any proposed procedure based on having all the necessary knowledge.
Okay, let's tackle privacy first.
Yeah.
The legal mandate surrounding confidentiality seems incredibly strict based on our sources.
It is. It's a non-negotiable duty. The rule is, any information the radiographer obtains during an examination must be kept in the strictest confidence.
Strictest confidence. What does that mean in practical terms?
It means exactly what it sounds like. Total secrecy. This covers everything. Diagnostic results, obviously, but also their medical history, demographic details like address or phone number, even the simple fact that they were a patient at your facility.
So you can't even mention, oh yeah, I saw Mrs. Smith today.
Not without potentially breaching confidentiality, unless it's strictly within the context of providing care and only with others involved in that care who have a need to know. The professional is essentially a legal guardian of this information.
And unauthorized disclosure. That can happen easily, right?
Very easily.
Right.
Accidentally leaving a patient's film or report where someone else can see it.
Mm-hmm.
Discussing a case, even anonymously, in a public area like the hospital cafeteria where others might overhear.
Or telling family members details without explicit permission.
Absolutely. All of those can lead to serious legal trouble, often under specific laws like HIPAA in the U.S., but also general principles of privacy law. And professional repercussions, too, losing your license, potentially.
And this commitment to privacy, it's essential for the next step, right? It builds the trust needed for the consent process.
Precisely. It underpins the patient's willingness to engage openly, which is critical for obtaining valid consent.
Yeah.
And our sources clearly distinguish between two main forms of consent professionals deal with, implied and informed.
Okay, let's break those down. Implied consent first.
Implied consent is the agreement you infer from a person's actions, or maybe their lack of action, rather than them explicitly saying yes.
Like what?
Well, the classic example is someone holding out their arm for a blood pressure check.
Right.
Or if a patient shows up for a scheduled x-ray, changes into the gown, and walks into the exam room. Their cooperation implies consent for those basic, usually non-invasive, preparatory steps. It's consent demonstrated by their conduct.
Okay, that makes sense for simple things. But when we get to procedures that are more invasive or carry higher risks or are just more complex, implied consent isn't enough, is it?
Absolutely not. That's when you must obtain informed consent.
Informed consent, let's define that clearly.
Informed consent is the patient's agreement to allow something specific to happen, like getting a contrast injection or undergoing a particular MRI sequence or even surgery. But, and this is key, it's based on a full disclosure of all the facts they need to make that decision intelligently.
Full disclosure.
The goal is to facilitate high-quality decision-making by the patient. They need to be truly informed.
That phrase, full disclosure, sounds like the legal tripwire here.
Yeah.
What exactly has to be disclosed for consent to be legally considered informed?
It's quite structured, actually. There are several components required. The practitioner has to explain the nature of the proposed procedure. What are we actually going to do?
Okay.
They need to discuss the expected or anticipated benefits. Why are we doing this? What good might come of it?
Makes sense.
Then, crucially, the known material risks. What could potentially go wrong? Even if the risk is small, if the potential consequence is serious, it generally needs to be disclosed.
Material risks.
Yes. And, very importantly, the available alternatives. What else could be done instead, including the option of doing nothing at all?
And the risks and benefits of those alternatives, too.
Exactly. So if a patient is considering, say, a complex angiography procedure, and the person explaining it fails to mention the known low but significant risk of stroke associated with it, that consent isn't truly informed. A critical piece of information was missing.
And the information, it has to be given in a way the patient can actually understand, right?
Yes.
Not just medical jargon.
Absolutely critical. If there's a language barrier, you need a qualified medical interpreter, not just, the patient's family member.
Right.
If the patient has cognitive impairments, you need to assess their capacity to consent and potentially involve a legal guardian or healthcare proxy. The professional has a positive obligation to ensure the patient comprehends the information.
So just getting a signature on a form isn't enough.
Definitely not. The signature is evidence that a conversation happened, hopefully, but it is not by itself proof of informed consent. If a professional just gets a signature without confirming, the patient actually understood the risks, benefits, and alternatives, and then something bad happens, an adverse event related to an undisclosed risk, the argument can easily be made that battery occurred. Why? Because the procedure was technically unauthorized due to invalid, uninformed consent.
Wow. So the burden is really on the professional. Ensure the patient gets the information, understands its risks, benefits, alternatives, so they can make what a reasonable person would consider an intelligent choice.
That's the essence of it. It protects the patient's autonomy, their right to choose, but it also serves as a vital legal defense for the professional.
How so?
If you properly document that you disclosed all the material information, including discussing risks and alternatives, and the patient, being competent and understanding, chose to proceed anyway, you've met your legal duty.
But if you leave out something important,
If you fail to disclose material information, it potentially invalidates the entire consent agreement.
okay, we've really established the liability that rests on the individual imaging professional for their intentional acts, like we discussed with torts, and also for unintentional failures, like negligence.
Individual accountability is clear.
But the reality is, healthcare isn't usually delivered by lone individuals. It's delivered by teams within organizations, hospitals, clinics.
Right, it's a system.
So how does legal accountability spread out? How does it extend beyond the individual tech or radiologist to involve the whole facility, the whole ecosystem?
This brings us to the crucial concept of vicarious liability, which primarily operates through a legal doctrine called respondeat superior.
Respondeat superior. Sounds old.
It is old, Latin again. It means let the superior respond, or sometimes translated as the master speaks for the servant.
Let the master speak for the servant? Okay. Doesn't sound very modern, but you're saying it's central to how healthcare law works today.
Absolutely central. It's the backbone of institutional accountability in healthcare.
So what does it mean in practice? What's the implication?
The core implication is this. The employer, which could be the hospital, the clinic, maybe the supervising physician in some contexts, can be held legally liable for the wrongful acts committed by their employees or subordinates.
Even if the employer didn't do anything wrong themselves?
Correct. As long as the employee was acting within the scope of their employment when the wrongful act occurred, the law essentially views the employee as an agent acting on behalf of the employer.
Okay.
And therefore, the employer, the superior, assumes the legal and financial risk for the errors made by their agents.
So let's take an example. A radiographer employed by a hospital working under a physician's general supervision commits a negligent act. Maybe they misposition a patient during an exam and it causes nerve damage.
Okay.
Under respondeat superior, the injured patient could sue not just the radiographer, but also the hospital and potentially the supervising physician.
That's exactly right. Both the hospital as the employer and potentially the supervising physician could be named in the lawsuit and held financially liable, even if they weren't physically in the room when the mistake happened.
Why does the law do that? What's the purpose?
There are a few reasons. One key purpose is to ensure that people who are harmed by medical negligence actually have a financially responsible party to seek compensation from.
Ah, the deep pockets argument.
Essentially, yes. Hospitals and larger clinics generally have more resources or insurance coverage than individual employees. It also serves to hold the organizational leadership accountable. It gives them a strong incentive to properly hire, train, supervise, and monitor their staff to prevent errors in the first place.
Okay, that makes sense. But the liability doesn't just stop at the employer answering for employee mistakes, does it? Our sources also talked about corporate liability. That sounds different.
It is different, though related. Corporate liability moves beyond just being responsible for someone else's mistake, which is what respondeat superior or vicarious liability is about.
Right.
Corporate liability means the healthcare facility, the corporation itself, has its own direct duties owed to the patient, independent duties to ensure a safe environment and provide high-quality care.
So the hospital itself can be negligent, regardless of whether a specific employee messed up.
Precisely. The facility itself has direct responsibilities. Failure to meet these responsibilities constitutes corporate negligence, and this duty often breaks down into a few key areas.
Okay, what are those main areas of direct corporate duty?
Well, first, there's the duty to properly screen and credential staff. The corporation, the hospital, must make sure it only hires and keeps staff who are qualified, properly licensed, and generally competent to do their jobs. So, if a hospital hires a technologist knowing they have a history of serious competency issues or maybe fake credentials, and that technologist then harms a patient, the hospital itself is directly negligent for that bad hiring decision. That's a corporate failure.
Okay, that's one. What's another key area?
Second, there's the duty to maintain safe and functional equipment and facilities.
Ah, the machines themselves.
Exactly. Imaging departments rely on complex, often high-energy equipment. The corporation has a direct duty to have adequate maintenance schedules, repair policies, and safety checks for all its machinery and the physical environment.
So, if a patient gets injured because, say, the hospital knew an X-ray machine had an electrical problem but didn't fix it promptly.
That's corporate negligence, a failure of the facility itself, separate from whether the technologist operating it did anything wrong in that specific instance.
Got it. Credentials, equipment. What's the third major area?
The third is the duty to implement and enforce adequate policies, procedures, and supervision.
Policies. Like safety protocol.
Yes, safety protocols, staffing levels, infection control procedures, guidelines for specific procedures, the whole operational rulebook. If, for example, a hospital knowingly understaffs the imaging department to save money, to the point where the remaining technologists cannot reasonably follow all the required safety checks or properly monitor patients, and that understaffing contributes to a patient injury, the corporation itself is liable for that systemic failure, for not providing a safe operating environment through adequate policies and staffing.
That's a really important distinction. Respondent superior is about the employee's mistake bouncing up to the employer.
Right, vicarious liability.
But corporate liability is about the hospital's own direct failures in hiring, in maintenance, or in setting up safe systems and policies.
Exactly. It's like a dual layer of legal responsibility. It's designed to ensure accountability right across the entire organization, from the individual practitioner up to the corporate boardroom.
And ultimately, this structure should force organizations to prioritize safety.
Right. That's the goal. It forces them to invest properly in safe staffing, good training, quality equipment, and robust policies, because they know the liability risk comes directly back to them if they cut corners anywhere in the system. It legally reinforces that standard of care we talked about, not just for the individual, but for the entire institution. #tag summary and conclusion. Okay, so let's try to pull this all together. To really synthesize the core legal framework we've unpacked today, if you're listening, you need to keep, I think, 3 major legal buckets in mind.
All right, bucket number 1.
First is that whole spectrum of liability. It covers both those intentional violations of patient rights, the torts we discussed, like battery, assault, maybe fraud, and perhaps more commonly, the unintentional failure to meet the expected professional standards, which is negligence. Understanding the specific elements needed to prove each type of claim, especially the role of intent in the intentional torts, that's fundamental.
Okay, intentional versus unintentional wrongs. Got it. Bucket 2.
Bucket 2 is your primary defense, your legal shield. Constant adherence to the professional standard of care.
Right. The reasonable, prudent professional standard.
Exactly. And remember, that standard isn't fixed. It's dynamic. It evolves with technology and best practices. It gets proven in court through expert witnesses and by looking at established organizational protocols and guidelines.
So staying current is crucial.
It's a legal necessity, especially because if an injury occurs that seems obviously wrong, that doctrine of res ipsa loquitur, the thing speaks for itself, might come into play, potentially shifting the burden of proof onto you to show you aren't negligent. Keeping up with the standard helps prevent those situations.
Okay, standard of care. Makes sense. And the third bucket.
The third bucket is all about upholding patient autonomy. This requires, first, rigorous maintenance of strictest confidence with all patient information. Privacy is paramount.
Not negotiable.
Non-negotiable. And second, it requires securing true, valid, informed consent, which, as we discussed, means much more than just getting a signature.
Right. Full disclosure.
Full disclosure of the risks, the benefits, and importantly, the alternatives. This allows the patient to genuinely exercise their basic right to decide what happens to their own body, to determine their own course of diagnosis and treatment.
So, torts and negligence, standard of care, and patient autonomy through privacy and informed consent. Those are the pillars.
Those are the absolute pillars of legal accountability in this field.
This has definitely been a deep dive into accountability, and hopefully, by absorbing these specific legal concepts, not just the definitions, but how they play out, you, the listener, are better equipped. Better equipped to navigate those really complex patient interactions, and also the administrative side, the hospital policies, to do it all with more confidence and, frankly, more prudence. Knowing the legal expectation.
Knowing what's expected of you as an individual professional.
Yeah, and also understanding that broader framework, the hospital's responsibilities, the system that's meant to support safe practice, but also holds everyone accountable.
Exactly. Which brings us, I think, to a final thought, something based directly on the tensions within the source material we reviewed. A point for you to really mull over as you take this knowledge back into your practice.
Okay, leave us with something to think about.
Well, we've established that the patient's fundamental right is self-determination, exercised through true, fully informed consent, a process that requires time, explanation, discussion of risks, benefits, alternatives.
Right, a meaningful conversation.
A meaningful conversation. Now, consider the reality of many modern imaging facilities, the constant pressure for rapid procedural turnover, high patient volumes, the operational demands for efficiency, for speed.
Yeah, the pressure is immense.
So the question to ponder is, how does that pervasive pressure for speed and efficiency practically challenge, maybe even undermine, the ability to achieve that ideal of truly informed consent on a daily basis? It's a real systemic tension, isn't it? Between the legal and ethical requirement for thorough, informed consent and the operational realities of a busy healthcare system. It's a negotiation every single professional has to navigate constantly.
That is definitely something to think about long after the scan is done and the patient has left the room.
Yeah.
How do we balance that duty with those demands?
Indeed.
We'll leave you with that thought. We'll talk to you on the next Deep Dive.